This is a video for my professional responsibility class about ABA Model Rule 1.17, the sale of a law practice. A lawyer or a law firm may sell or purchase a law practice or an area of their law practice, including goodwill, if the following conditions are satisfied. First, the seller ceases to engage in the practice of law or in the area of practice that has been sold in that geographic area or jurisdiction in which the practice has been conducted. The entire practice or area of practice is sold to one or more lawyers or law firms. You can't sell it to a non-lawyer. The seller gives written notice to each of the seller's clients, and that's going to include the following. First, obviously, the proposed sale. Second, the client's right to retain other counsel or take possession of the file. And the fact that the client's consent to the transfer of the client's files will be presumed if the client does not take any action or otherwise object within 90 days of the receipt of the notice. If a client cannot be given notice, the representation of that client may be transferred to the purchaser only upon entry of an order so authorizing by a court having jurisdiction. The seller may disclose to the court in camera information relating to the representation only to the extent necessary to obtain an order authorizing the transfer of a file. The fees charged client shall not be increased by reason of sale, so you can't just jack up everybody's fees because you bought the firm. And that concludes our video about ABA Model Rule 1.17, which covers the sale of a law practice. I'm Drew Stevenson at South Texas College of Law.